Good afternoon, and thank you for everyone for joining me this afternoon. For those of you who do not know me, my name is Gina Campanella. I am the principal attorney of Campanella Law Office in Wyckoff, New Jersey. And I also have an office of convenience in Pearl River, New York as well. And I practice in New York, New Jersey, Vermont, the District of Columbia, and Pennsylvania, and also on a federal basis. The law that we're going to be talking about today, the No Surprise Bills Act, is a federal law. So whatever state you are joining us from, this law does affect you. There will be a couple of occasions where I say check with your state laws to see if there's something more restrictive or something that will affect this. If you are in one of the states where I practice, I'd be happy to speak with you about your specific state laws and compliance as well. So let's get started. So today's presentation is taking the surprise out of the No Surprise Bills Act. And I have primarily designed this presentation today as a primer for providers. So if you are joining and you work for a hospital or a large multi-specialty system or something like that, this will be a good overview for you, but it's really primed for the small and mid-size provider, whether in or out of network. So what is this? Where did this come from? What is it? Why did suddenly everybody wake up in December and realize they had to do something new? Where did this come from? So this law originated in the Consolidated Appropriations Act of 2021. That is the formal name of the bill. And it was established with the purpose of protecting patients from surprise medical bills. As many of you, I'm sure, know, we do have a problem across the country with patients going to in-network facilities, thinking that all of their care is going to be in-network, and being treated potentially by out-of-network providers without any notice or opportunity to request an in-network provider. And then they get an astronomical balance bill, and there's nothing they can do about it because they consented to the care. What this law does is try to now prevent that and prohibit that. A lot of times when I'm speaking to my clients, I'll say to them, you know, yes, this bill is awful, I'm so sorry, but we have to comply with it. This particular bill, the No Surprise Bills Act, I actually think this one is more good than bad. And I do think that it will have more of a positive effect for your patients than negative. But how do we make sure that it doesn't have a negative effect on you? Okay, it applies to insured and uninsured consumers, and it is applicable to all services that are provided on or after January 1st of 2022. Okay, so this is applicable now. It went into effect January 1st, 2022. I do tend to believe that there will be a little bit of a grace period for people to get up to speed, especially small and mid-sized practices. I don't think hospitals or large systems are going to be getting any kind of a grace period. But I do tend to believe there would be a little bit of grace for small and mid-sized practices. So if you haven't implemented any of the things I'm going to be talking about today, I wouldn't necessarily go into a panic that you're going to be targeted. However, I would make sure that you put that on top of your priority list to make sure you are doing it immediately, or very much as much near to immediately as you can. Okay, so who is included in this? Any patients that are covered by a group health plan, anyone covered by group or individual health insurance, anyone covered by federal employees' health benefits plans, and of course the uninsured. This is intended to not only protect the uninsured from astronomical bills, but it is also intended to protect people who have plans from surprise out-of-network bills. So who's not included? This is actually very interesting, and this is something that I like to make sure that my clients are aware of, especially when I have clients who have a primarily Medicare practice or primarily military-based or something like that. This does not include, and it specifically does not apply to Medicare, Medicaid, Indian Health Services, Veterans Affairs Healthcare, or TRICARE. Why not? It seems like all of these government programs would want these types of protections. Well, it doesn't apply because all of these government programs already have the same or similar protections in place. So Medicare, Medicaid, Indian Health Services, Veterans Healthcare, and TRICARE, which is the group health plan for active duty military, all of these plans, because they are government plans, already have these protections in place. So you don't have to worry about patients who are covered by any of these plans or programs. I will mention too, if you have any questions throughout the presentation, I am always happy to answer questions. There is a question box where you can type in your questions. There's also a chat box. I will be monitoring both of those. So if you have questions, please feel free to type them in, and I will have the opportunity to ask questions at the end as well. Okay, so now we get to the good part. I've told you where it came from, given you a little bit of background on the purpose. So what exactly does it require, right? First and foremost, there are now particular prohibitions on balance billing. Basically, if you see a patient who's out of network and you get reimbursed a certain amount from their out-of-network benefits from their insurer, unless you are complying with this bill, you cannot now balance bill them for the remainder anymore. You do have to disclose these balance billing protections to your patients. You have to have transparency with the healthcare costs that you're going to charge. There are now protections as to continuity of care for patients. And there are some provider directory requirements. I mention these just so you know that they exist, but that's not really what we're going to focus on today. And we have a question. Okay, so the question is, are you saying we cannot charge our full fee and allow clients to seek reimbursement with a super bill? No, that's not what I'm saying at all. And I'm going to go through the steps you have to put in place to still be able to do that without any issue. Keep in mind that a lot of this applies to emergency care and things that are supplemental to emergency care. So we're going to go through what situations it applies to, and then we're going to go through what you need to have in place in order for your patients to consent and agree to your out-of-network fees. That was a very good question. That's often a fear that a lot of people have, that suddenly there's no point in being out of network because you can't balance bill, but that's not the case. So let's talk about balance billing, okay? The prohibition on balance billing applies to providers and facilities, and there are enumerated requirements for facilities and providers, okay? This is very critical if you are an out-of-network provider and you provide any kind of services in an in-network facility. If you cover the ED, that's the emergency department, at an in-network facility. If you see patients who have been admitted from the emergency department at an in-network facility, if you provide supplementary care to patients who are in in-network facilities. This is very critical for you because you need to know what your facility is doing, and there are also things that you're going to now be responsible for yourself. So let's get down to the brass tacks. You absolutely cannot balance bill for emergency services that are provided by out-of-network providers or out-of-network emergency facilities. Absolutely no balance billing for certain non-emergency services by out-of-network providers at certain in-network facilities. And no balance billing for any air ambulance providers. I did take a look at the registration list, and I'm fairly confident that we do not have any air ambulance providers on the call with us today. So again, this is something that I am putting in there just so you know it exists. We're going to touch on it, but what I'm really focusing on today is this emergency services concept and what out-of-network providers can do to make sure that they're compliant, but they can still collect their entire fee. So what is an emergency service, right? Any service provided to a patient who presents seeking emergency care for a condition that a reasonable layperson would think was an emergency. Okay, why is there this type of particular language here? Because they want to avoid the situation where someone presents at the emergency room with a condition that a reasonable layperson would truly believe was an emergency. However, once they're triaged, the emergency room says this isn't an emergency. You did not have to come to the emergency room for care. You could have waited and seen your primary care physician. Oh, and now we're going to balance bill you for everything. Okay, so if the reasonable layperson would think that the condition the person was suffering from was an emergency and present to the emergency room for that care, that is the standard, right? Any services available to the emergency department to assist in determining if an emergency condition actually exists, right? Because under EMTALA, the emergency departments all have the obligation to triage and stabilize patients. So any services available to the emergency department that are utilized in determining during triage and stabilization if an emergency condition actually exists are considered emergency services for purposes of this law. Post-stabilization services that are part of outpatient observation or an inpatient or outpatient stay related to the emergency visit. Okay, again, that's very important. If someone develops a secondary condition, as they very frequently do when they're in hospitals, the secondary condition does not count as an emergency service. It doesn't get these protections. But the primary condition and any post-stabilization services for the primary condition, the one that the patient presented to the ED for, is still considered under that umbrella of emergency services. Now, this is to my viewer who asked the question at the outset, consent and waiver exception. This is going to be the bread and butter for most of you. Most of you who are on the call today, I actually know. Many of you are my Cornerstone clients. And so we've discussed this likely already. And I put this together with a view towards that type of practice, my small, solo, out-of-network practices. Okay, so you can give your patients a consent and they can waive their right to basically be protected from out-of-network balance billing under this law. If you have a fee schedule that your patients sign, make sure that it is completely separate from any other document. You can no longer have the consent to your fees in the same document as the consent to treatment or on the same piece of paper where people are giving you their emergency contacts or anything like that. It needs to be a completely separate document, and there are certain things now that need to be in that document. Obviously, the patient's name, the provider's name, okay? So it's not just the practice's name, but it's the practice name and the exact provider that the person is going to be seeing or getting treatment from. You do have to have a statement that the provider is out of network and a good faith estimate of the amount the patient should be charged, may be charged rather. Now, I've had a lot of people contact me and say, oh, I heard that I have to, you know, tell patients now what my fees are, along with, I have to tell people now what my fees are along with their diagnosis and how much I think they're going to spend in the next year. These are some strict corners of this statute, but it does say good faith estimate. Okay, I have a lot of clients I work with that very validly say, well, I can't give a diagnosis before or even after the initial consultation. It may take 3 or 4 appointments before I actually have a diagnosis. That's okay. The name of the game here is that you need to make sure that you're making the client aware of that, and that's all part of this informed consent. Okay, so a good faith estimate can be, this is what an initial consultation costs. This is what a follow-up consultation costs. I can't tell you right now how many follow-ups you may need. However, I anticipate you're going to need this many. If that changes, we will discuss it, when you'll discuss it, how you'll discuss it, things of that nature, okay? You do have to have a statement in there that prior authorization or other managed care limitations may apply It is your responsibility to make sure the person knows that they may not get reimbursement when they submit that super bill to their insurance company, okay? And if you are a facility, then you do have to give a list, or if you're at a facility, okay, let's say you're out of network and you're doing your call coverage at the hospital where you have privileges, if you're providing those non-emergency services and there is a reasonable opportunity for someone to consent and waive the exception, you do have to give them a list of in-network providers available at the facility for the same services. Okay, so when do these documents have to be provided? You have to provide these documents to the patients at least 3 days prior to the patient appointment. Okay, so this should be going in with your patient intake package that you send out to patients electronically or what have you when they make their appointment. Because the requirement is now that they have to have these documents at least 3 days prior to their appointment. The idea behind this, they can read it, they can think about it, they can talk to other people about it. Perhaps if they want to price compare, they can do that. If a patient books with you fewer than 3 days out, then as soon as the appointment is booked, then you need to send them these documents. In any event, it can't be fewer than 3 hours before the appointment time. Okay, they can sign everything when they come in, but they have to be provided documents on this 3 days/3 hours timeline. Okay, so how do the documents have to be provided? I said already that it has to be in a separate form. It can't be combined with any other consent or intake forms. And it's really at the patient's preference, if it's electronically or on paper. What I'm recommending to most of my clients is send it electronically. You have your EMR, that's what it's for. And then if a patient requests it on paper, then you have to figure out how to get it to them on paper. So what I really want you to take away from this one point is that you can, as a rule, send them out electronically, but if a patient requests it on paper, you have to comply with that request. I have another question. It says, should we say anything about diagnosis beforehand, like to be determined, etc.? And if so, do we have to send another document once the diagnosis is determined? No. Right now, my answer to that is no. And my answer may change once we see how the government is going to enforce these provisions. But right now, by my clear reading of the bill, I think as long as you disclose that you cannot determine the diagnosis before or at the time of the first appointment, however, you make it clear that once a diagnosis is determined, you're going to share that with the patient, disclose it to the patient, and update the treatment plan. I don't think you have to send another document. I do think it's good practices and it's in everyone's best interests to have the patient execute another document if your care plan is going to be more frequent or more expensive than you originally estimated in your first good faith estimate. So for example, if your original fee document with that patient says, we're going to see you for initial consultation, and then I anticipate we're going to see you once a week thereafter for a period of 3 months, and then you determine that you really only need to see the patient twice a month for the next 3 months, I don't necessarily think that you need to worry about having another document executed because you're less than the good faith estimate. If you then diagnose the patient and realize, oh my goodness, this patient really needs twice a week treatment for maybe 4 or 5 months, then yes, in that situation, I would absolutely have another document executed because now you're going above your good faith estimate. And there are rights that the patients now have if you go a certain amount above your good faith estimate. So below, I'm not super concerned about. Above, I definitely think you should have them fill out a new form. Okay, I have another question. The question is, do we need to send this to clients who started with us before January 1st, 2022 and are still in our care, or only to new clients who came to us after 1/1/22? You need to give this to all of your patients, all of your clients, both current and new and existing. Okay, again, this is somewhere where the law is not super clear, but my interpretation of it is that it applies to all patients because it doesn't specifically say it only applies to new patients. So my advice is this is something that you should be executing with all of your patients, you know, whenever they come in for their next appointment throughout the month of January, even if it goes into February, depending on how frequently you see patients, because whether they were your existing patient or a new patient, they have these rights now. And these rights came up and started on January 1st, 2022. There's no differentiation as to whether or not they needed to be a new patient, or if it was existing patients as well. So my interpretation of the law is yes, existing patients needed it as well. Okay, so I do have a question for clarification. If the provider is out of network and pays, and I'm assuming it's if the provider's out of network and the patient pays the fee, does not sign the waiver, and insurance pays, we cannot balance bill. We can, okay, so yes, the clarification is you can only balance bill when this consent and waiver is signed. And yes, that final question there that I see right now, this is being recorded, and I will have the recording posted on the firm's YouTube channel. And it should be up there in about 24 hours. Okay, so let's get back to, I'll pop back over for more questions in a bit as they come in, but let's get back over to the main portion of the program. Okay, so consent and waiver exception. Now the question is, can I refuse to treat a patient who refuses to consent? Absolutely. Okay, you're still a private practice. This is not an emergency situation. If you have a patient come in and say, well, I'm not signing this because I don't want you to balance bill me. I want you to just get whatever you get from my insurance. Ha ha, I can do this now. You can say, okay, well then I'm sorry, but our practice is not going to see you. That's perfectly fine. That's the same way that you can refuse to treat a patient who doesn't sign your clinical informed consent. Okay, or you can refuse to treat a patient who refuses to consent to your practice policies. Okay, so you absolutely can refuse to treat a patient who refuses to consent. Be very careful when you're putting together your compliance, because if you do not comply with even one requirement of this act, you cannot balance bill. Okay, so you want to be very clear that your existing and new patients are all signing these new fee consents, okay, fee agreements, fee consents, because if you do not comply with even one requirement, a statement's missing, something like that, you cannot balance bill. Finally, patients can revoke their consent, but it has to be in writing and it has to be prior to treatment. Okay, so you can't have a patient sign this and then, you know, in the middle of their treatment saying, oh yeah, by the way, I don't consent to that anymore. Or after treatment saying, oh, this is your bill? I didn't understand that, I'm not consenting anymore. Okay, the consent has to be revoked in writing prior to treatment. So there's a little bit of protection for the physicians and providers there as well. All right, going out of network. This is something that a lot of my clients call me about as well. Hey, Gina, I'm going out of network. What do I do? What are my requirements? What do I have to do? Okay, if you go out of network while you're already caring for in-network patients, typically under your third-party payer agreements, there's already going to be a certain requirement for some type of continuity of care. It's typically 30 days or 60 days, something like that. You have to continue to provide care to in accordance with your third-party payer agreements with the payer, with the insurance company, in order to give that patient time to find a new physician or provider. Be very aware that this bill now makes that 90 days. So no matter what your third-party payer agreements say, you now have to accept payment from that plan issuer for up to 90 days after the patient has been notified that you're going out of network, and that is to protect continuity of care. All right, you do have to have a posted notice. Okay, no, you are not required to put your prices on your website. This is a question that I have been getting a lot. There are other laws that require certain facilities to put pricing on their website. That's where I think the confusion is coming in, that I'm getting some confusion from my clients on this, but no, this law does not require you to put your prices on your website. And unless you're a certain type of facility, you're probably not subject to having your prices on your website. Okay, question came in. Can I clarify balance bill? What if patients pay your fee and they choose to submit to insurance for reimbursement? Either way, you have to still give them the fee agreement, and you have to still give them the notices, and they still have to sign it. Because what can happen is you can get fined now, or you can get in trouble if you didn't notify the patient that you were out of network and they had these certain rights under this bill. Okay, so even if you don't, and that's actually how I advise most of my out of network clients to function. If you're out of network, my advice to you is actually just to let the clients pay you, give them a super bill, and let them deal with their insurance directly. It's cleaner, and it's easier to be compliant that way. But if you do that, then you still have to give this, notice, you still have to have them sign the consent, because they still need to consent to give up that right. Okay, so the next question, if we sent electronically through EMR, I know it will be HIPAA compliant. If that's not an option, would there be an issue at email and HIPAA, since it will have diagnosis codes? Yes, unfortunately, this is something that you're not going to be able to send via non-encrypted email. So you're going to want to send it through the EMR. You're going to want to send it through an encrypted email system. Or, even if the patient's local, they can come in. If they don't want it through EMR, they can come in and pick it up. But you really want to encourage your clients, unless they have some type of inability to do so, to use the EMR on this one. Another really good question, what does this notice have to say? Just you have legal protections against balance billing, nothing else? No, and I'm actually going to give you a sample notice that CMS put together that I think is great and should be used. And I'm going to give you a link to that at the end of the presentation. Okay, so you must post this notice to the patient that they have legal protections against balance billing. It needs to be posted in the office. It has to be on your website if you have a website, or a link to it on your website. And it specifically says it has to be on the home page or a link to it on the home page. My suggestion is to link to it on your home page, because it's a 3 pages. It's a couple pages, the complete notice. And it also has to be in your consent and waiver. Now, the sample notice I'm giving you, the extent of that notice doesn't necessarily have to be in your consent and waiver. There are other ways you can put the notice in your consent and waiver. I've actually put some language together that's short and it's in plain language that I believe is compliant. The sample consent I'm going to be giving you from CMS, that's really more the type of thing I would recommend that you just address to the general public by hanging it in the office and putting it on your website, or a link to it on your website. Consent and waiver can be a little bit more tailored and personalized to be simpler and a little bit less overwhelming. Okay, so here's the sample notice. Okay, so if you go to CMS files, okay, disclosure notice, patient protections against surprise billing, providers, facilities, health. All right, this is the link here. And what I'm actually going to do is when I send the follow-up email for attendees, I will put this link in the follow-up email, so you guys can all click through this link. So you'll have this link here. When you open this link, there's going to be several pages of instructions, and then the last 2 to 3 pages are the actual sample notice document that you want to conform to your practice and use. And I always love when CMS or New Jersey Department of Health or New Jersey Department of Labor gives us beautiful sample forms. Any of you who have worked with me know that if you can get something perfectly sufficient from the government, don't pay me, don't pay someone else to do it for you. When there are free resources out there for you. There are plenty of things that people need to come to me for. When something perfectly sufficient is out there and it's free, go for it, utilize that resource. Okay, so when the balance billing prohibition applies, if there is no state law or all payer model agreement applicable, the out-of-network provider may accept the initial payment from the third-party payer, or you may enter into a 30-day open negotiations period to negotiate the payment. All right, so now we're going into the conversation. We're going to kind of end the presentation with this conversation. What happens if I'm in a situation where a consent and waiver wasn't signed? I submit my bill. I'm willing to take whatever the insurance company gives me, and then the insurance company basically pays me like $5, when reasonable fee would have really been like $500 or something like that. You can enter into that 30-day opens negotiation period to negotiate that payment. Okay, if those negotiations fail, then you can elect to enter into independent dispute resolution process, or IDR, and take it a step further and go into a formal process of negotiating that payment with the third-party provider. While you are doing this, you cannot involve the patient and you can't bill the patient. Okay, so as you can see, the consent and waiver path is probably going to be the most financially viable for most, if not all of you. This negotiation and IDR process, this is really meant to assist and give some type of remedy to the people who are out of network, who are providing those emergency services and now cannot balance bill, to try to attempt to give them some semblance of protection where they can reject the first offer from the third-party payer and go back and ask for more. From where I sit as somebody who regularly represents physicians and providers and practices, this is a very hollow and meaningless attempt to provide protection. You know, you're basically saying, oh, well, if they don't like what they give you, then you could just not get paid for several months and spend money and time going through this IDR process, where anyone who has experience with third-party payers probably realizes that it's going to be very difficult to get them even close to the numbers that would make you whole. So I do encourage everybody to make sure that you are getting your consents and waivers in place and you're utilizing them immediately in your practice. Okay, again, just be aware, if you are out of network, you are responsible for determining if the facility at which you have provided services is in network for each patient. Okay, so you now have to take an active role in determining if the patient you're treating is in network at the facility where you're treating them. If you even bill a patient that you shouldn't be billing, you can be subject to fines and corrective actions. Even if the patient immediately calls you and says, why did I get a bill? And you say, oh my goodness, I'm so sorry, that was a mistake, rip it up. Don't worry. You can still be subject to fines and corrective actions just for doing that. So you need to make sure that your billers that you use are on board, whether they're in-house or you use a third-party billing company. You need to make sure that everyone is being compliant with this and that they're up to speed and they're doing the right thing. Okay, so finally, just like everything else that unfortunately affects my physician and provider clients, patients can very easily file complaints. Okay, as I often say when I'm giving presentations on board matters and board compliance, when people used to want to file a board complaint against you, they had to go through all of the effort of finding paper, writing a letter, finding an envelope, getting the address, putting a stamp on the envelope, finding a mailbox, putting it in the mailbox. You know, it was a lot more effort. They had to feel very passionate about their complaint to go through all of that effort. Now, they simply Google, how do I complain about this? and a nice little website comes up that they can just click on and file a complaint against you. Okay, so you need to just be very hyper aware of the fact that you have to be making a good faith effort to comply with this law. Like I said, I think that there may be some changes in what attorneys like myself are advising their clients as we see how this is going to progress and how it's going to really be integrated into reality. But right now, strict reading of the law, this is my interpretation. This is how I advise you all to go forward. And some of you on the call, I actually know that we already have gone over. You are currently my clients. I know we have gone over your fee schedules. Anybody who is a current client who would like to send me your fee schedule, or if you've sent it and I haven't gotten back to you yet, send it again. Let's make sure we go over it. As you can imagine, I had a lot of clients sending them to me, and I just want to make sure I didn't lose track of anybody. And if you don't currently work with a firm, I'd be happy to speak with you about assistance that we can provide. So that's really the crux of the presentation. Does anybody have any additional questions? Anything that you've heard that maybe I didn't talk about that I can dispel the rumor? Any questions anything that maybe you want me to talk a little bit more about, how to implement these things or anything like that, please feel free to put those questions in the question box now. I think that, most people are going to be in a very good position to do this. Most out-of-network providers that I work with and I have worked with already have these types of fee agreements that they have their clients signing and agreeing to simply by the nature of providing a service for a fee and wanting to make sure that you get paid. So a lot of you already have the skeletons of this, and we just have to kind of put the meat on the bones. Okay, another question. Okay, it says, we bill immediately after services, and most of our clients submit super bills for reimbursement. If the client doesn't agree with the reimbursement amount, are we to step in, or is that just for providers who get reimbursed from insurance? That's an excellent question. No, that is just for providers that get reimbursed from insurance and have agreed to not balance bill. So if you have a patient and that patient has not signed the consent and waiver, and you are still willing to treat them and just take whatever you get reimbursed from insurance, that negotiation is for you, okay? If your patient doesn't like what they get back from their insurance, that has nothing to do with you. That's between the patient and their insurance company. Okay, the next question is, please clarify the difference between consent and waiver and the other documents from CMS. All right, so your consent and waiver, that's a document that you are going to put together. It's going to be separate from all of your other consent and client intake documents, and that's basically going to be an enhanced version now of what you're probably already using as your fee agreement or your payment agreement with your clients or your patients. And that document is going to have the notice, a short, brief notice to patients that they have rights under this law, that this law exists and they have rights under this law. And you're just going to make sure that you're presenting your fee in such a way that you hit all of the other requirements. For example, good faith estimate of total fees. If you can't provide a diagnosis before you first see them, if you can't provide a diagnosis when you first see them, then when will you provide a diagnosis? How is it going to be provided then? Could it potentially change the good faith estimate? The document I gave you from CMS, that's just like a generic wall notice. That's something where you can literally just print out the last couple pages, conform it to your practice meeting, put your practice name on it or whatever, what have you. But you could utilize it directly from CMS, and that can be the document that you put on your website and the document that you post in your waiting room. Okay, another question. So to clarify, even though I bill as an out-of-network provider, they pay me in full, and it is completely up to the client to submit my bill to their insurance company, I still have to give them this info and have them sign it. Yes, that is 100% correct, because you need to make sure that they understand that they are completely responsible for the difference between what their insurance company is going to reimburse them and your out-of-network fee. Okay. Next question, is this only for out-of-network providers in an in-network facility? No, it's not. It is critically important for out-of-network providers in an in-network facility, but if you're an out-of-network provider in your own private practice, you still have to give these notices and you still have to have the consent and waiver signed in order to be collecting your full out-of-network fee from your patients. Okay, another question. If the patient signed a consent and waiver, patient paid the fee, but insurance pays the provider, are we to refund the insurance payment and keep the patient's money? Yes, that's correct. If the insurance sends you the check for the insurance reimbursement to the patient in error, instead of sending that check to the patient, then you are going to sign that check over to the patient or send the patient the refund for that check. If they have not signed the consent and waiver, then you would have to refund the patient all of their money. So that's why you see now where these consent and waivers really become critical. Okay, so again, to just make that very clear, if a patient has signed a consent and waiver, patient has paid the fee, but for some reason insurance sends you the check to reimburse the patient instead of sending it to the patient, what you owe the patient is the amount from the insurance, not the total of the fee, if you have the signed consent and waiver. If you don't have the signed consent and waiver, you're going to end up having to refund the patient the entire fee and only be able to keep what insurance sent. Okay, so I don't see any more questions coming across. If you have any additional, oh, I'm sorry, one more question. So they have to sign the consent and waiver and a good faith estimate. The technical answer to that is yes, but the practical answer is your good faith estimate and your consent and waiver are going to be the same document. It's all going to be in the same fee schedule. And this question is actually coming from a current client of mine. So please, you're welcome to send me your fee schedule and we'll get it fixed up for you. Okay, so thank you all so very much for being here with me this afternoon. I hope that you found this valuable. I hope that you got good information, and quite frankly, I hope that this has relieved some of your concerns about this bill. Unfortunately, it's going to be more paperwork, but I do think that the complications are able to easily be overcome by having the correct paperwork and clear paperwork in place. Again, if anybody would like assistance, please don't hesitate to reach out to my office. Happy to provide assistance in getting you up and running. I will have this presentation on the firm's YouTube channel within the next 24 hours if anybody came in late or had to leave early, or if you'd like to share it with somebody who couldn't be here with us today. So look for that on the firm's YouTube channel in about 24 hours from now. And I will send that link when we send out the follow-up email to attendees of the presentation. Thank you again so much for being here with me today. Thank you for your time. I wish you all the best of luck. And I hope you got value from this presentation today.